Implementing the APS-Initiated Elder Abuse Restraining Order.
My name is Shelley Jackson. I'm a consultant with the Elder Justice Initiative, and our mission is to support and coordinate the department's elder justice efforts. And we do this by promoting justice for older Americans, by helping older victims and their families, by enhancing state and local efforts through training and resources, and supporting research to improve elder abuse policy and practice. We also manage the department's Elder Justice website at elderjustice.gov, and we invite you to take a look at our website. There are resources for all kinds of professionals, and there is lots of information and other resources available there. So that brings us, sorry, we're going to do the poll question in just a moment, but that brings us to our webinar topic today, and that is restraining orders. And as I said in the announcement, there are many types of restraining orders, but in general, a restraining order is an order issued by a state court with the purpose of preventing one person from harming another person. So in this webinar, we're going to be focused on elder abuse restraining orders. And if they're available, they're typically found in the APS section of your state code. And don't quote me, but there were about 16 states with an elder abuse restraining order statute, so there's not that many of them. But it can be a valuable tool, and we wanted to share with you the experience of one county in implementing this type of statute. I had the privilege of attending a session at NAPSA 2 or 3 years ago where our presenters were really honestly describing the struggles they had in implementing this statute and the success that they eventually achieved. And I thought it would be really beneficial for other people to hear the lessons learned and how their restraining orders currently function out of the Riverside County APS. So before I introduce our speakers, I did want to, we have a couple poll questions. We want to know who our audience is today, who's joining us. So what is your professional affiliation? And you can see that there were a number of options here. If you want to take our poll and let us know who. A lot of adult protective services, good. Okay. Good, so we've got the majority are adult protective services, but we've got civil legal, aging services, healthcare, law enforcement, and the Elder Justice Initiative webinars typically have a range of professionals, very multidisciplinary, so this is terrific. Okay, so let's do our next poll. And then we want to know what your experience is in working in elder justice. And so our 3 options are none to a little, you're kind of new to this, somewhat experienced or extremely experienced. And that kind of lets us know who our audience is again. Well, this is good again. We've got a real mix, probably almost half somewhat experienced, but we've got people from little experience to extremely, and yeah, breaks out very nicely. So good. Let's close out that poll. And now, whoops, not that one. Oh, sorry. Okay, let me introduce our speakers now. It's my privilege to introduce Raymond Mistica. He's the Deputy County Counsel 4 with the County of Riverside, and he's assigned to the Riverside County Adult Protective Services. And then Julie Orozco is the Regional Manager, Adult Services Division, Riverside County Department of Public Social Services. So Raymond and Julie, I will let you take it from here. I forgot to mention that we are going to be taking questions at the end. So if you'll put your questions in the chat, we're going to move some of those over, and then we'll save about 10 minutes at the end to come back and answer your questions. So we welcome your questions in the chat box for now. Okay, Julie and Raymond, please.
Thank you so much for the introduction. We're looking forward to sharing Riverside County's experience in implementing the APS-Initiated Elder Abuse Restraining Order. So as Shelley mentioned, there are elder abuse restraining orders that states are using. Today we're going to specifically speak about the APS-Initiated restraining order, which is a little different, where it's APS can actually petition the court to implement a restraining order. So we're going to go ahead and jump into that. Ray, would you like to start?
Yes, thank you, Julie. And thank you for that introduction, Shelley. So what we have here on this slide is an overview of the different types of restraining orders that one may pursue if applicable. And there are, at least in California, generally 5 types that might apply to protecting elders and dependent adults. The first one on this list is an emergency protective order. Those are usually brought by law enforcement, and they have a short duration of only 5 court days. When we have elders or dependent adults that are in imminent danger and law enforcement is involved, a lot of times an EPO will be sought. The next type of restraining order is a criminal protective order, which requires a criminal case that is filed in a criminal court and are brought by district attorneys. The other one that can be used is a domestic violence restraining order, which is under the California's Family Code. This requires a specified familiar or household relationship between the restrained party and the protected party. And this is brought by the abused person. Another one is a civil harassment restraining order, and this is brought by the abused person as well, but would not generally apply to neglect or financial abuse type cases. And then what we have here is the number 5 on this list, which we are talking about today, is the Elder or Dependent Adult Protective Order, which is found in Welfare and Institutions Code 15657.03. This applies to elders who are 65 years and over and dependent adults. And we'll go into more details with regards to the statute. Next slide, Julie.
I wanted to give a little background regarding the AIRO. And so as local counties, sometimes we identify an area, a problem, or a challenge. And so back in 2014, Riverside County identified that we had a challenge where there was elders that we wanted to protect, but they lacked capacity, were unable to protect their own affairs. And sometimes families who were the suspected abusers in some of our investigations were actually prohibiting us to have interaction with them so that we could intervene. And so in 2014, we actually submitted a legislative proposal to allow Adult Protective Services to be able to petition for a restraining order to protect elders that or dependent adults that were unable to protect themselves. And so in 2014, we submitted that proposal, and fortunately for us, through lots of different, lots of things happened, right? But in 2016, it actually became law. So that was a huge success for us. We were very excited. And you'll see on your screen which WIC codes were modified by that becoming law. But essentially, it allowed us to file a restraining order to protect an elder or dependent adult who lacks basically the ability to protect themselves, right? They have an impaired ability to appreciate and understand the circumstances that place him or her at risk. The other part of the statute also allows us to file a restraining order on behalf of an individual who maybe doesn't lack capacity, but for whatever reason, they're fearful or they don't feel like they can file on their own, and they've given us written authorization to file on their behalf. So those are the 2 areas that we are allowed to file on. So when it came to implementation, so once we knew the law was approved, we had to quickly figure out, okay, how do we put this in place? And so the first thing we did, for other counties that are looking to implement, is we just scheduled an implementation meeting and scheduled a series of meetings. And it included APS staff, it included county counsel, it included the public guardian and different folks with the probate court, because these were all the different agencies that were going to be involved. We did quickly determine that county counsel had to be involved because we needed to be represented in these. We could not just go in and represent ourselves. And so county counsel had to be involved, and they would be the ones filing our petitions. We decided to designate an AIRO coordinator, and we'll talk a little bit more about that throughout the presentation, but we decided that it would be helpful to have that coordinator in place so that it really narrowed the point of, it basically created a point of contact for, especially for county counsel, but for our staff as well. So when they were considering an AIRO petition, there was one person they could contact to get started. We wrote internal procedures, right? And I'll tell you, this was a little backwards for me. I'm a planner, and so I like to have all the procedures written out in advance before we do something. But then we had the opportunity to actually, we identified a case where we decided that we were going to try it out. And so we had written down what we thought would happen, but rather than trying to finalize all of that, we decided to go ahead and submit this case and basically write down what happened. We wrote down how the case went through, and it was a great method for this thing because, as you know, these are urgent. Someone's in danger, and we wanted to quickly act. And so we were able to kind of put it through the system and just really write down how it went. And then at that point, once we knew how it would actually work in real life, that's when we finalized policy and we made presentations to staff for training. And so I usually don't work backwards in that way, but in this case, it really helped.
So the legal authority under Welfare and Institutions Code 15657.03, as Julie did mention before, there are two scenarios in which APS can bring or petition a court for an elder abuse or dependent adult abuse restraining order. It may be brought where the elder or dependent adult has an impaired ability to appreciate and understand the circumstances that place him or her at risk of harm. Under that scenario, APS would be required under the statute to make a referral to the public guardian. And then the other scenarios where the elder or dependent adult has some capacity or has capacity, but for whatever reason is afraid to pursue a restraining order, APS can then step in, but the statute requires written authorization, and that's also for the protection of APS. In the event that you have an elder or dependent adult kind of going backwards and denying whether they or not they gave APS authorization, if you have it in writing, that will protect APS from liability if they were to pursue. The burden under the statute is not stated, but we have case law in California that applies that a protective order can be issued upon reasonable proof of past act, and it's a preponderance of evidence standard. The cases are cited there in the presentation if you want to look those up. And just to let you know that the court has broad authority to enjoin any specified behavior. So there are sections, and we're required to use the judicial counsel form for filing the petition for elder abuse or dependent adult abuse restraining orders. And there are parts there where you can ask for specific additional orders that the court can take into consideration. Next slide, Julie.
Okay, so when you are considering whether whether the AIRO is appropriate for you, so there's a couple of things we recommend. We definitely recommend, the first question for APS is the client in imminent danger of abuse? And so when we can say yes to that question, that's when we know, okay, we have to intervene in some way. The second question is really, does the client have an impaired ability to protect him or herself or their assets from the abuse or the exploitation. And third, does the client remain vulnerable to continued victimization, right? So if we leave them in the current circumstances, the current situation, are they likely to have continued victimization? And to us, if those answers are yes, then the AIRO is definitely something that we consider as one of our possible interventions.
Julie, I think we skipped the slide. Can you go to the prior slide to this?
Yes.
Just to let everyone know, there are some limitations under the statute when you're seeking to exclude a suspected abuser from the residence. First of all, the person that you're trying to get protection for has to have a legal or equitable title to the residence in order to get a kick-out order on a suspected abuser. And then the other thing that needs to be shown to the court is that there has to be some physical or emotional harm that would otherwise result to the APS client. So if you don't have those two items, the court may not kick out the suspected abuser from the home. Also note that there is a time requirement so typically when we file the petition, many times the court will issue a temporary restraining order. Typically it's a day after filing, if not on the same day, depending on what time the petition is filed. Then the court sets a hearing on the permanent to hear the case to issue a permanent order. Generally speaking, that's within 21 days. You can move it out to 25 days with good cause. But don't be surprised if the court actually sets a hearing less than 21 days, such as a week or a week and a half. That has happened before to us. And the duration of the permanent restraining order, once issued by the court, is not more than 5 years. If the court doesn't specify a time, then it's understood to be 3 years. Next slide, Julie.
So I covered the 3 bullets. Do you want to talk about evidence, Ray?
Oh, yes. So under the bullet point, do we have sufficient facts, evidence that abuse has occurred? From County Counsel's point of view, that's important because the evidentiary code does come into play, and just wanted to note that Probate Code Section 1000 says that the rules of practice applicable to civil actions apply to probate proceedings. That would include the evidence code. So hearsay objections are usually the objections that we have to take into consideration when providing sufficient facts and evidence, and that's the main one that I look for to determine if we have the right facts to prove the case.
Perfect, thank you. The other things that we will look at is if there's other protective measures. We'll consider whether protective measures have been insufficient to mitigate the abuse, right? So sometimes, let's say we can put a rep PA in place. Sometimes we can have somebody take over as power of attorney. If those other interventions are successful, then filing an AIRO may not be necessary. So we will talk those through, and it's only when we realize either it's not going to be helpful, we've tried it and it's failed, that we will try to do something a little bit more significant, such as the AIRO. The other thing that we do consider is whether there's a reliable third party that is going to help. So for example, let's say we have a client who it's the caretaker, it's their own caregiver that is the abuser. If we implement an AIRO and we remove that person from the environment, then who is left to take care of the elder? And so oftentimes we're partnering with a public guardian, or there's other family that will step in, but it's really important that that is considered in advance to ensure that the elder or dependent adult isn't left alone without supervision.
So utilizing the AIRO and other interventions. So what this chart shows is kind of um, the types of protective orders that might come into place and their timing. And it's important to show that an AIRO can be a stopgap measure between your EPO and the CPO. So as I mentioned earlier, the EPO is the duration is about 5 to 7 days, business days. And then for a CPO to be issued, there has to be an active criminal case. So between an EPO being issued and, there's going to be investigation being performed by law enforcement, and, it'll take some time before the DA actually files charges. There might be a period where we need to protect the elder or dependent adult, and that's where an AIRO might be useful. It's a useful tool to put into place that if you have the facts to show that there is abuse that happened and is needed to protect the elder or dependent adult. And like I said, an AIRO, a TRO is typically granted based on the pleadings about within the same day or the day after. And then you have the hearing up to 21 days. And then if the AIRO is granted, you have from 3 to 5 years. So if the AIRO is granted, then there's plenty of time to for the DA to complete their investigation and to charge, and that AIRO will be in place by the time that happens. Next slide, Julie.
When we were implementing this, I just wanted to share a couple considerations or challenges that you may want to think about. So number one, I shared before, we determined pretty quickly that we needed county counsel involvement. So for sure, if anyone is considering implementing the AIRO, definitely connect with your county counsel, because you will need them to submit the petitions for you in court if it works the same for you. Something to think about, it is time consuming. It's not simple. It's not a super fast process. To us in Riverside, we have determined that it doesn't matter how time consuming it has been worth it for us. It has allowed us to protect our clients at a level that we didn't have before for these really tough cases. And so for us, yes, it's time consuming, but it's completely worth it in the end if we can intervene and protect a person and their assets. Definitely highly recommend that utilization of a specialist. That is really important. I don't know if Ray, if you want to add a little bit more to that, because I think that's been helpful for you.
Having a specialist on the APS side to help put together all the documentation and get the evidence together makes the time-consuming aspect not be so burdensome, because at the end of the day, it's presenting, substantial evidence or, preponderance of the evidence sufficient to get the court to order the restraining order. So having a specialist on the APS side who is familiar with all the judicial counsel forms that need to be completed and to be submitted as a packet is very helpful in this process.
And on the APS side, given that, the AIRO isn't something that you're going to do every day, so our social workers who are generalists, this is going to be done so infrequently for each of them. There's not really the ability to develop specialty or, expert knowledge. And so having someone to really have that knowledge and experience submitting multiple AIROs is very helpful for the APS team as well. We also experienced some initial, when we decided to implement AIRO, all of a sudden it became the new tool, and everybody was like, let's do an AIRO. How about an AIRO? And it was viewed initially as this like fix-all solution. And so we definitely want to caution everyone. It's not the solution for every case. And it really isn't supposed to replace other interventions, right? So, sometimes, for example, in speaking with other counties at different webinars, they were looking at this maybe as a solution for, public guardian can sometimes, establishing conservatorship can take a long time. Can we do the AIRO instead? Because, the conservatorship takes a while to establish. And I would definitely say this, this is not equal to conservatorship. To me, they each have their own role, and they can benefit clients in different ways. And we definitely have used the AIRO in partnership with conservatorship, but to me, I don't see them as equal to one another. And so we just have to remember the intent of the AIRO versus the intent of some of our other interventions. And then also, part of the restraining order is identifying criminal history and different types of records that are helpful for the petition. And so we have found that it is helpful to have some type of interagency cooperation as far as access to criminal records and so forth. So we have the information we need to be able to add it to the petition. The other things that we want to just remind you of is that, like we said before, there's definitely repercussions when you remove a caretaker. And so you want to make sure you have those plans in place. And we have learned over time that it's really nice to be able to tailor the order to the facts of the case. And so, just because we have found that somebody is not a good caregiver and actually places the client at risk, that, let's say it's their mother, their adult child, that doesn't mean we don't want them to have contact ever again. It just means that they're not the appropriate caregiver. And if that relationship was to continue, the client was at risk of, significant injury or even death. But that doesn't mean that we don't think they should visit and have an ongoing relationship. And so we will consider those things, for example, when doing the orders, that maybe if they're in a facility and it's a supervised visit, that should be fine, as long as it's, monitored. The other thing is, your social workers will have to testify if it gets to the part where maybe it's contested or there's a trial. Ray here with us, we didn't know that some of these were going to go to that, level, and we have had, I think, at least 2 that have gone to. If it wasn't a trial, because I'm not maybe using legal language, it definitely felt like a trial, and so there was testimony, and so that is something that we weren't quite prepared for, and so we had to really figure out how to train and prepare our staff. Again, it wasn't a training that we had to give to everybody, but it was definitely guidance and coaching that we had to provide to social workers ahead of time. And then finally, we have an active community. We have lots of community partnerships. We have lots of different multidisciplinary team meetings that we have in Riverside County. And sometimes, ultimately, because we're the ones filing the petition and APS, we have the ultimate decision on whether we're going to use the AIRO or not. And sometimes, at the beginning, there was a couple cases where they were really tough and other agencies were recommending use of the AIRO, and we decided not to. And so we face some criticism and why aren't you using this tool that's at your disposal? And so we have to be prepared to address those questions and talk about why we felt the AIRO was either right for this case or not right for this case. Anything you want to add, Ray?
Yes, Julie. With regards to the bullet point regarding tailoring the order, I can't stress enough how important that is, because the last thing the judge wants to do is separate family members unless the facts show that separation is needed. And if you're throwing in the kitchen sink and asking for everything, a kick out, stay away order of 100 yards, things of that sort, and the facts don't bear that, that's one way to lose getting a TRO. And if you're thinking of it as a stopgap measure and you need that TRO, throwing in the kitchen sink where the facts don't support it is one way to not get the TRO.
Benefits that we've experienced in Riverside is we definitely get to protect our most vulnerable clients. We have found that it, does serve somewhat as a gap measure. So if we can get the EPO, but that's only really going to protect someone for, those 5 days. And then, there might be criminal proceedings. There might be public guardian conservatorship being considered. And all of those things are great, but it really allows us to protect the client while all those other measures are happening and moving through the process. It gives the legal authority to help protect the client. So I don't know if you've ever experienced this, but we've had at times where our client is hospitalized and, we're asking the hospital, can you please not allow this person to visit? Can you please, because we were afraid that they were going to check them out AMA. can you please, register this person as Jane Doe, just so that it's not as easy to locate them. And the hospital is hesitant, right, if there's no legal paperwork that allows them to really do that. And so by having this paperwork in place, the hospital or other facilities really have the information they need to be able to, adequately protect and safeguard our client. And it allows law enforcement to enforce the order, right? Without that order, it's really hard for them to be able to step in and intervene. And this is what they need in order to enforce that order. So it's been very beneficial for us. So far, we implemented in August of 2016. And so I looked at some of our stats. And so just so you know, we've submitted 15 AIROs total. And again, we don't see it as a solution for all cases. And so we really try to determine whether it's the right one. So in total, in that time, we've submitted 15. All of them were immediately granted temporary restraining orders. So the initial facts supported that, that the TRO be granted, which is done the same day of submission. Every now and then, the court may have more questions, and maybe it's not immediately granted, but most of them are. Of that, 11 of them actually reached the permanent status. And so just to kind of talk about what happened with the other 3, we had a client who unfortunately passed away before the permanent was issued. We actually withdrew one ourselves because we were able to have other protective measures put in place, and we no longer felt the permanent restraining order was necessary. And then we had 2 that were denied. So I think it was with those 2 that went to that trial place. But basically, the court in the end found that we didn't have sufficient evidence. We didn't meet our burden of proof, right, to really justify that permanent restraining order. I don't know if you want to add anything else to that, Ray.
At least on the one that was denied for permanent restraining order, that went through a long evidentiary hearing, kind of a mini trial. And there's conflicting evidence on both sides. And I think the basis for that restraining order was a suspicious break in the left femur. But there was contradictory information or evidence. So the judge in that case determined that burden of proof was not shown by APS. But for the most part, it's been successful when we do file it. And I think that it's worth the risk than not pursuing it.
And then just to share too, we also document when we consult on an AIRO, but decide not to go that way. And so we've had about 18 consultations on cases that we decided that AIRO wasn't the right solution.
Or there are better solutions, right?
Right. Thank you. So we're gonna, we think that things kind of come full circle and make more sense when you actually can apply them to some cases. So we have 2 case presentations that we're going to try to get through so we can share just some examples of how it's been applied. And so really quickly, the first case we're going to talk about, Jane Doe, she's 87. And at the time of our intervention, she was living at home with her son, daughter, and son-in-law. And I included some medical history in case those attending are interested in that. Something really interesting about this case, so this case is actually our first AIRO that we did. And ironically, when we were going through the different hearings for the legislative proposal that we submitted, you have to go and testify before, Senate and stuff like that to be able to talk about why this is so important. And we actually used this case example because this was a lady who we've had lots of history with, and we wanted to intervene and protect her, but her family hid her from us. And even though we had law enforcement, district attorneys all like staking out the house trying to get in touch with her because we wanted to do an assessment of her capacity to determine, her ability to basically protect herself, and so that we knew how to intervene appropriately. But there was some prior elder abuse hearings and so forth against that family that were going on, and so they hid her from us so that, number 1, she couldn't be a witness in those prior cases. Number 2, we could not assess her capacity, and number 3, they were really living off her financially as well. And so we were so excited that we had the opportunity to test out the AIRO on the case that we actually really led us to file that restraining order legislative proposal. So this criminal history, we had the daughter and the son-in-law with prior elder abuse convictions. We literally had this family, you know, if you see things in public, they actually had hit and kicked and punched their own mom in public on a couple different occasions, which was witnessed by people, and that's why law enforcement was involved. So you can imagine if they're that blatant in the public eye, what may be going on in the home. We also had APS history, right? So we had a history of, at the time when the client had capacity, for refusing services, insisting on returning home with her family. We had a history of her going to the hospital and then checking herself out and the suspects checking her out against medical advice, and a history of them hiding, you know, her from us. So we had a long history with this family. And so when this case came back to us back in August 2016, unfortunately, a hospice worker walked in on the client's own son sexually abusing her. She was often lacked capacity and had mobility issues, and he was sexually assaulting her at the time of the visit. So she walked out, called law enforcement, they were dispatched, and they arrested the son, and they also arrested a son-in-law because he was violating a previous order that he should not be around our client. And so the client was hospitalized because of the nature of the abuse. She was hospitalized, and we quickly went into action to implement the AIRO. We conducted a joint visit at the hospital with APS, a DA investigator, and one of our neuropsychologists to really assess capacity and understand whether she had capacity or lacked, and it was determined that she lacked capacity. And then we went ahead and filed our first AIRO. So we completed the packets, we worked closely hand in hand trying to figure all of that out. We filed the AIRO with the court, and you can see, you know, this is just a matter of days. So this all came in on August 25th. By September 2nd, the AIRO was filed. And I should say that law enforcement issued an EPO at the time of the first day, so that really allowed us to have a few more days to complete the AIRO paperwork. That day, it was received by the court, and the TRO was granted. The next step was the court set a hearing for the permanent restraining order, and at that restraining order, the 3 restraining orders were granted. So this was not one that went to trial or anything like that. It was not contested. Well, I shouldn't say that. Now I'm using language. I don't believe it was contested. Ray can correct me if I'm wrong. And really, we felt that our client was safe. And so in this, you can see how quickly it went, right? This all came in August 25th, and by September 22nd, we had permanent restraining orders in place. We also had public guardian working to conserve her. She was in a safe place. While public guardian was considering conservatorship, we actually had families step up and said they had no idea all this was going on, and they intervened, and they ended up actually getting conservatorship. Recently, I looked up these cases just to find out what was the status of the criminal convictions, and you can see that you know, there was some prison time granted for the son. The daughter is actually still going through trial, ironically, this many years later. And then the son-in-law was charged as well with cruelty to an elder, and looks like he got some probation and some different things. But we had some great positive outcomes to be able to quickly use that AIRO, which really allowed us to intervene and protect this client like we had never been able to do before in the past cases. Anything else you want to mention, Ray?
This example is one where there is physical abuse, and it's you know, you can see on there, you know, we have rape and cruelty and elder assault, and so it's a very significant fact pattern and really one that needed to be pursued.
Okay, and then I'm going to quickly go through the second example because I know we're running short on time. But our next example, we're going to call John Doe, 80-year-old male. He was living in a memory care facility. There's some of his medical history in case you're interested. That we had no prior APS or criminal history on this family, but essentially APS got a referral from a facility saying that they had not received rent for the past 9 months for this person, and the past due rent was now totaling over $28,000. The son was the identified party responsible for making payments, and he was also responsible for paying for the father's medications, which he had not been doing that either. So APS went out the following day, and we conducted our first contact with the client. We identified and determined and confirmed that, yes, the son was the responsible party for managing the finances. We determined the client had dementia. And but the next day when we went out, we realized he was now $30,000 in arrears, and it was at risk of being evicted. And so we realized, the client definitely has enough monies coming in to cover all of his expenses. He was earning $12,000 plus a month. And so he definitely had the monetary support to be able to cover his placement and all of his needs. And so this actually got assigned to a special unit in our county that we just recently created that's assigned for financial abuse allegations. They quickly placed a hold on all of the client's bank accounts and retirement funds so that we could intervene further but ensure that not additional assets were lost. We requested bank records to assess all the activity, and we determined that the son and his wife were using the client's monies for things that were not related to his care, regularly transferring money between the clients and their accounts. And they were taking out personal loans, but paying the loan payments back with the client's money. So we assessed, just with our assessment, that there was a total loss of at least $350,000. At that time, we decided to pursue the AIRO because the son was, so even though we were putting stops and safeguards on all of the client's accounts, he continued to try to access the client's money, open up new accounts, transfer funds into another account. And so our interventions just were not able to, they weren't sufficient to be able to ensure that his assets were safeguarded properly. And so we were able to request an EPO from law enforcement, which was granted. And then we went to work on the AIRO. We submitted the AIRO, and the temporary AIRO was issued. And then, just a couple of weeks later, they issued the permanent restraining order for 3 years. So this, at the very beginning, we were hesitant to do financial cases, but this is one where we were able to demonstrate with enough evidence that the AIRO was really needed in order to safeguard this client's assets. Is there anything you want to add, Ray?
This case is an example of there were other basis for which we were seeking the AIRO on this one, but the focus of this case was on financial abuse. And if you looked at that timeline, when you're dealing with financial abuse type cases for restraining orders, there is a longer period of time from when we get when APS receives the first referral or notice of the case to the time of filing, because you have to go through bank records. And what was very helpful in this case is that the social worker, and I believe Pamela is on this, attending this webinar, the social worker put together an Excel spreadsheet outlining the specific charges, showing that these were charges not related to the care of the elder. And that is essentially kind of what you really need, and it's attached to the petition, but it's because you're going to get a lot of bank records, and most of them, you may not need, but the ones that are important to highlight, it's good to have an Excel spreadsheet outlining all those and tallying up the total of charges that were used not for the benefit of the APS client. And this is also a case where the court set, after the issuance of the TRO, the court set the hearing on the permanent restraining order in about a week, which was a really quick turnaround, and which was to our surprise. But we had that hearing, and actually it went to an evidentiary hearing because the respondents contested the evidence, and so there was witness testimony in that case.
So in this case, though, we definitely had some great outcomes, right? We were able to issue the EPO and the AIRO. A granddaughter stepped up and became and filed for conservator so that the client could remain with family. We were able to secure his housing and avoid an eviction. And with us safeguarding the assets, by the time we closed the case, he had already accumulated $51,000, which would have all been gone if we had not intervened. And law enforcement later was actually able to get a written confession from the son. And so charges right now are being drafted, and by the end of this year, will be filed with the DA. So we had some good things happen on this case.
Yeah, and also in this case, the son and the son's wife actually testified, and which is, I mean, that's their choice. We have other cases where respondents actually plead the fifth and don't testify, and that creates some procedural issues and delays in the outcome of the case. But when you have the ability to take their testimony on a witness stand under oath, it could be helpful to the district attorney who may end up filing charges in this case. This is one example. We had another case where the son in that other case also testified, and I just take the advantage of asking any and all questions related to the subject matter to create a record. Whether or not it's results in victory on our end, it may be useful for the district attorney.
You want to take us through some legal lessons learned?
Sure. Thank you, Julie. So as we've mentioned multiple times here, be prepared to conduct an evidentiary hearing. Typically, restraining orders are granted on the petition, on the face of the petition, because they are verified and signed under penalty of perjury. But what we've learned is, at least the ones that I filed, majority of them actually ended up going to evidentiary hearing. And so presenting your witness, typically it's going to be your APS social worker who's your primary witness, but you also have to bear in mind hearsay objections, which is the most typical objections you'll find in such a hearing. So you have to make sure that your witnesses have firsthand knowledge, unless you can find an exception to the hearsay rule. And like that last case, the court can set a hearing on the permanent restraining order very quickly. So it doesn't have to be 21 days after initial filing. It could be short of that 21 days. So be prepared for that as well. Service sometimes could be an issue, especially if you have a person that you have to personally serve in terms of the suspected abuser or the respondent to the restraining order. And so in California, using the sheriff's office, it's free to process serve. But for harder to serve individuals or out-of-state individuals, you might want to look into a professional process server in those cases. Also, in cases where criminal charges are pending, as I mentioned earlier, the respondent may plead the fifth, and because of that, the court may delay the hearing on the permanent restraining order. On the ones that I've had where that has occurred, the court did continue the temporary restraining order, and actually in one case, it was continued so often that eventually the DA actually filed criminal charges and a CPO was granted. So we were able to reach a stipulation on that case to grant a permanent restraining order that mirrored the CPO. Julie, do you have any other comments?
No, that's it. I'll go to the final slide. And I'll only stay a second on here because we really highlighted these here, but we just definitely want to push that the AIRO can be a valuable tool to aid APS in our effort to protect our vulnerable clients that we work with. We have learned that it is also especially helpful with financial abuse because it helps us to safeguard someone's assets sooner. And while it's a time-consuming process, we found that we've had positive outcomes for our clients, and we just really strongly recommend that coordinator. It really does, especially for Ray and your county council. It really helps them and helps us develop some expertise and knowledge within.
I fully agree. And
okay, so we've reached the end, and I think we're going to have a facilitator help us with some Q&A.
Great. So again, thank you, Raymond and Julie. That was terrific. And as you say, this is a tool in your tool belt. I think we learned a lot of lessons that I think can, help us avoid some of the initial pitfalls getting started. So we're going to do Q&A in just a moment, but we do have one last poll question. You're already hopping on it. How helpful did you find this webinar? And then we will go over and take some questions here. Just one moment. Okay, so we also wanted to let you know that if we don't get to your questions, we've got about 8 minutes left. If we don't get to your questions, you can certainly email us at elder.justice@usdoj.gov, and we will answer your questions after the webinar. So, all right, let's see if we can get started. I'm going to ask Thais to move the poll just a little bit out of my way. Thank you. Okay, so our first question is perhaps for Raymond. In case of suspected elder abuse, should I contact local and state authorities or federal authorities? Does FBI have a role in this at all?
Well, in California, we have mandated reporting. If you're not a mandated, and APS actually has a 24-hour, 7 days a week hotline to report any suspected abuse of elders or dependent adults. But certainly you can contact law enforcement if there is imminent danger to the individual. But certainly you do report something that you've seen or suspect in terms of elder or dependent adult abuse. But certainly APS has a hotline. Pretty much all counties in the state of California has a hotline to report elder and dependent adult abuse. And
Yeah, it's actually
once
a
that's
requirement.
yeah. Julie, and just to mention, and even if it's not something that APS would handle, maybe it's not related to an elder or dependent adult, it will be referred over to the appropriate agency for handling.
Absolutely. I was just going to say, is it a requirement? It is a requirement of California that all agencies have a 24-hour service of some sort to be able to take those calls in. And so I definitely recommend, it's confusing. It gets confusing on who to call and jurisdiction. So you can always start with Adult Protective Services. And if it's their jurisdiction, they'll take the case. And if it's not, they'll either cross-report or they'll educate you on and who the appropriate agency is to contact. So they're a good place to start.
Okay, good. So we have had people from all across the country. This is somebody from Ohio asking whether all states have at least similar laws that apply. I believe they're asking whether there are APS-initiated restraining order laws in other states.
You mentioned a statistic earlier on, but not all states, I believe, have a similar statute. Only maybe a dozen or so.
Okay, I think that's about right. I've counted 16. I say don't quote me, but you want to contact me later or contact the Elder Justice email address up here. We can get you that information. So Talitha, I'm so sorry. I'm going to ask you to shrink that just a little bit for me. Thank you. Okay, so our next question is, if a client lacks the capacity to make a decision for themselves, and as a caseworker, you feel the client is being harassed by the alleged perpetrator, can the caseworker file a restraining order without the client's consent?
So that really is the beauty of the AIRO, right? And that's when, so if the client has capacity, we can help guide them on how to file their own restraining order. But if a client lacks capacity and they're not able to, which means that they're not able to consent usually, right? Because they don't understand what's happening. Then that's really when this tool comes into play, and you can use this to protect them. So I saw that question as well. Consent is not an actual requirement of the AIRO because we are basically presenting the facts that they don't have the ability to consent. Ray, do you want to add anything?
Yeah, and the standard lacks the ability to appreciate the harm, right? So if the client lacks that ability, then the AIRO does come into play. That is the first hurdle. It looks like you get over that first hurdle, then it's proving the abuse. So I think an AIRO would, if you have one in your state that's similar to what we have in California, would be a useful tool in that situation.
And can I clarify one thing? So I do believe those laws that we referenced, like there are elder abuse restraining order laws. I don't think many states, I'm actually not aware of others, but that doesn't mean that they don't exist. I don't know of other states having a process where APS can file other than California. So we'll have to do more research about that.
Okay. Now we have a question that I think we often hear on elder abuse webinars, but if the elder is getting abused but doesn't want to report it or press charges, what steps can we take to keep them safe?
Julie, can you handle that question? It
Sure.
sounds like not
Yeah. Yeah, so I think it kind of depends, right? How do we learn about so the AIRO comes into play when we receive a referral, we receive allegations, we're doing an investigation, and we determine that yes, they are being abused, exploited, neglected, and they lack capacity and cannot protect themselves. And so the AIRO is a way for us to step in and protect them. So, you know, if it kind of depends. I want to go back to the beginning, right? So it depends on, we may not ever know in this situation that they described, but I think, most people working with elders, you're mandated reporters. And so to me, if you are observing that somebody's being abused, exploited, neglected, then it's your duty to report to APS. As far as not wanting to pursue criminal charges, the reality is in California, if it's a penal code violation that we're investigating, then we do have the ability to move forward the investigation, cross-report, interview folks, to move things forward without their consent because it's a penal code violation. So just hopefully that answers the question.
Of the fact pattern, it sounds like the person has capacity, but is just a reluctant person to do something about the current situation. And I think they're asking is, what other remedies are there? Well, if the person does, in terms of elder abuse, and assuming that the fact scenario is involving a dependent adult or elder, if that person is reluctant to file a restraining order, an elder abuse restraining order, just because they're afraid, just to remind everyone, the statute does allow APS, even when the person has capacity, to file if they provide written authorization. But from APS's standpoint, we have to look at whether or not the person is in imminent danger that places them at immediate risk of harm and bodily injury. But there may be other avenues, but certainly if it is reported to APS has to conduct an investigation of all reports of abuse. And they may not have to do anything, but APS might end up referring it to law enforcement, and they may also conduct an investigation. If they confirm that there's something going on, then law enforcement may refer it to the district attorney's office.
Okay, well, I can't believe it's 3 o'clock, so our time is up. We have one more question that somebody was asking whether the slides are going to be available. They will. The webinar will be recorded, and it will be available in about a week on the Elder Justice website. And if you registered, you'll get the link to the recorded version and the PowerPoints as well. So I'm sure our audience joins me in thanking Ray and Julie so much for this informative webinar. I think it is so valuable, and I appreciate you spending some time with us and sharing your wisdom and experience for other communities and APS workers across the country. So thank you, and have a good rest of the day.
Thank you, everyone.
Thank you.